States. Mr. Unikowski.
Mr. Chief Justice, and may it please the Court. The question in this case is not whether, but instead how, to hold people accountable for absconding from supervised release. The text and history of the Sentencing Reform Act establish that Congress intended for revocation, not fugitive tolling, to be the means of addressing abscondment. To begin with the text, the effect of the government's position is that Ms. Rico was subject to the conditions of supervised release for a period exceeding the time specified in her judgment, and there's no textual support for that result. The government claims that Ms. Rico wasn't serving her sentence at all during the period of the abscondment, but that argument cannot be squared with the government's simultaneous contention that Ms. Rico violated the conditions of supervised release during that period, warranting an increased sentence. History supports Ms. Rico's position. Contrary to the government's contention, there is no common law tradition of fugitive tolling for parole. Instead, fugitive tolling for parole came to exist via a 1976 statute and a 1983 implementing regulation. But in the Sentencing Reform Act, Congress prospectively repealed that statute and enacted nothing in its stead for supervised release, while leaving it intact for legacy parole cases, and it remains intact today. As a result, Congress has created a two-track scheme: parole with fugitive tolling and supervised release without it. And we ask the Court to adhere to that dichotomy. I welcome the Court's questions.
Well, Mr. Unikowski, the government seems to be arguing, making a simple point. How can it be considered supervised release when the absconder is not being supervised?
Your Honor, I completely understand the intuitive force of the government's argument that the essence of supervised release is being supervised, and if a person absconds, they're just not serving the sentence at all, in the same way as a prison escapee isn't serving the sentence at all. But ultimately, although I understand the intuitive force of that argument at first blush, I don't think it carries the day, because the government's arguments has a counterintuitive component of its own, which is that it requires believing that not only was Ms. Rico subject to the conditions of supervised release during the entire abscondment period, but she actually violated those very conditions during that period, warranting her increased sentence. So it just seems to me almost tautologically, if Ms. Rico violated the conditions of supervised release, she must have been serving the very sentence that imposed those conditions of supervised release. I do understand the intuition underlying the government's argument today that it just doesn't really make sense that a person should get credit when they've absconded. I get that. But I think that one point that really blunts the intuitive force of the government's position is that both parties agree that ultimately the absconder should be deprived of credit for the time spent absconding. The sole question between the parties today is very narrow. It's how that deprivation of credit should be effectuated. So the way we understand the Sentencing Reform Act, if a warrant issues based on the abscondment, as occurred in this case, then once the person is apprehended, even after the term expires, the person can be brought before the sentencing court, and then the judge revokes supervised release and strips the person of all credit for time served during the abscondment period. So essentially the judge, rather than stopping the clock keeps going, and then the clock is rewound back to the beginning.